kind of started off my morning with some good information. And that is involving the Trump case down in Hotlanta, down in Georgia, the RICO case. And if you guys remember, that was a case involving Trump getting indicted for RICO along with 19 other people. It was a case where we saw Fani Willis, the brave, proud black woman who was the Fulton County District Attorney, leading the charge against the evil Drumpfler and the rest of the gang, including Rudy Giuliani, Mark Meadows, and many other people. Well, this is the one also where we saw people like Jenna Ellis turning to rats, just cheese-eating rats, and snitch out as they plea. We need to start with that, just so you guys remember what happened here. And yes, this is from Brendan Dilley. And he says, reminder, Jenna Ellis was the only one to roll over and take a guilty plea in the Fani Willis election case. Yep. She's the only one that rolled over. So anyway, here is Jenna Ellis giving her plea, and here's her statement. Just remember this, guys.
Thank you, Your Honor, for the opportunity to address the court. As an attorney who is also a Christian, I take my responsibilities as a lawyer very seriously, and I endeavor to be a person of sound moral and ethical character in all of my dealings. In the wake of the 2020 presidential election, I believed that challenging the results on behalf of President Trump should be pursued in a just and legal way. I endeavored to represent my client to the best of my ability. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were in fact true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, I failed to do my due diligence. I believe in and I value election integrity. If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges. I look back on this whole experience with deep remorse. For those failures of mine, Your Honor, I have taken responsibility already before the Colorado bar who censured me, and I now take responsibility before this court.
Her and then some other attorneys entered pleas, but they were also part of diversion agreements, which once again, as one of the things I've pointed out this entire time, if the prosecutor is letting the hatchet men, the attorneys who were plotting and scheming for this overthrow of democracy, and they're getting diversion agreements, were they really that bad to start with? I submit to you that no. And also an acknowledgement, they have a dog shit case. In the meantime, chat, in the Court of Appeals for the state of Georgia, today, the rest of the people involved, including the current president-elect, Donald John Trump, Rudy Giuliani, Jeff Clark, and many others, appealed and went to court to deal with their issues surrounding Fani Willis and her disqualifications. This is part of, and as they point out, it was a 97-page indictment with RICO violations, all about the 2020 election. Now, remember, guys, they are appealing for the trial court's order denying their motion to dismiss the indictment and their motions to disqualify the Fani Willis as the district attorney in the case. So they're appealing two things. Where we get to this, they talk about the case. There's a lot of history here. But that part, you guys have probably known a lot of it. This is the stuff where we learned about people like Ashley Merchant, and we learned about her, who then later became to prominence during the YSL trial, coming to defend Brian Steele when he was being sentenced for contempt for defending Young Thug zealously. The whole cast of characters at that point. We learned about like Adam Abadi. We learned about Assistant District Attorney Love, Assistant District Attorney Hilton. And we learned about Fani and all of her secrets and everything that she's done. And her just years of scumbaggery. Well, we get to the actual part of this that's important. So they point out that based upon the factual findings of the trial court and its order, and the state's failure to cross-appeal the trial court's finding of a significant appearance of impropriety, they agree that there was an already existing appearance of impropriety And the odor of mendacity, as Judge McAfee had said, existed. And they say, as our consideration of the appearance of impropriety is limited to the remedy. It's limited to the remedy fashioned by the trial court. So that's where they have to start. They say, we turn to Georgia law on this issue. How do we do it? How do we do it? The remedy is fashioned by the trial court. They said, well, the parties advocate for diametrically opposed bright line rules. And that's true. Disqualification of the district attorney's office can never result from an appearance of impropriety, or disqualification should always result when the elected district attorney engages in activities that raise the appearance of impropriety. And they say Georgia law requires neither as a matter of course. They say instead we must examine the particular facts and circumstances of each case while keeping some general principles in mind. They say, and that's fair. You got to analyze it case by case. And their first principle is the trial court's ruling is reviewed for an abuse of discretion. And they say, second, the issue of attorney disqualification is viewed as a continuum, meaning it's not just one action, but it's the course of actions. And they say, at one end of the scale where disqualification is always justified and indeed mandated, even when balanced against a client's right to an attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidences. And they say in these types of situations, it's clear disqualification is necessary for the protection of the client. And they say somewhere in the middle of the continuum is the appearance of impropriety based on the conduct on the part of the attorney. And they say this has generally been found insufficient to outweigh the client's interest in counsel of choice. And they say this is probably so because absent danger to the client, the nebulous interest of the public at large of the propriety of the bar is not weighty enough to justify disqualification. And they say finally at the opposite end is the appearance of impropriety based not on conduct, but on status alone. And that's an insufficient ground for disqualification. And they say that the appearance of impropriety may be grounds for disqualification of a prosecutor. And they say here we must address the remedy in the context of a significant appearance of impropriety caused by the conduct of a public prosecutor. And here they talk about the responsibility of a prosecutor differs from the usual advocates. The duty is to seek justice, not merely to convict. And they say they should exercise restraint and the discretionary exercise of their governmental powers. And they argued that they're more than an advocate for one party, and they have additional responsibilities. Their role is as an administrator of justice, and they have broad discretion in making decisions prior to trial about who to prosecute. And they say these considerations take this case out of the continuum of cases involving an appearance of impropriety in connection with the conduct of private counsel and the client's interest in counsel of choice, balanced against the more nebulous public interest. And they say, after considering the trial court's findings in its order, we conclude that it erred, meaning it failed, chat. It messed up by failing to disqualify Fani and her office. The remedy crafted by Judge McAfee to prevent the ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed when Fani was exercising her broad discretion about who to prosecute and what charges to bring. So it didn't matter. It didn't matter that he could fix it going forward. The damage had already been done, and that damage was fatal. And they say, while we recognize that an appearance of impropriety is generally not enough to support disqualification, this is the rare case in which disqualification is mandated, and no other remedy will suffice to restore confidence in the integrity of the proceedings. Yeah, and they talk about a case here, and it's called Head v. State, and where they address the appearance of impropriety based upon status alone, when the investigator with the alleged status conflict took no part in the investigation or prosecution. And they talk about another case, Billings, where the assistant district attorney with the appearance of impropriety did not participate directly or indirectly in the prosecution after joining a DA's office. And they say here, on the other hand, Fani Willis and her boyfriend, Special District Attorney Nathan Wade, have been actively involved in the case since the inception. And that's true. She basically hired her boyfriend and paid him $1 million. And they say, accordingly, we reverse the trial court's denial of the motion to disqualify Fani in her office. And they say, as we conclude the elected district attorney is wholly disqualified from her office, the assistants whose only power is derived from the authority of the district attorney who appointed them have no authority to proceed. So that means not just Fani, but her entire office. They're done. And from here, they talk about the second part of this. The appellants contend the trial court erred in denying their motions to dismiss the indictment. And they argued, the prosecution argues the state failed to show how there was an error in finding that their due process rights have been violated or that the issues involved prejudice them in any way. And they point out dismissing an indictment is an extreme sanction used only sparingly for unlawful governmental conduct. Well, I mean, we're dealing with some unlawful governmental conduct here. The prosecutor's doing some pretty sketchy shit. And they say in the absence of an express statutory authorization, dismissal of an indictment generally cannot be imposed absent the violation of a constitutional right. So they're saying, yes, there was a lot of misconduct, but no constitutional right appears to have been violated. And they'll say why this is the rare case in which Fani Willis and her office must be disqualified. We cannot conclude the record also supports the imposition of the extreme sanction of dismissal of the indictment under the appropriate standards. We therefore affirm the trial court's denial of the appellant's motion to dismiss. So affirming the trial court means they're supporting it. So they argue the appellant's remaining enumerations of error are rendered moot by our holdings in Part 1 and Part 2. So it's affirmed in part and reversed in part. It's a 2-1 case, chat. There is a dissent in this as well. So what does that mean? It means Fani and her office, they are off the case. They're done. They can't be involved anymore. The case is not dismissed, though. It's not dismissed. It's not going away for now. But because Fani can't do it, well, who takes over? Well, in this case, they have what's called the Prosecuting Attorneys Council of Georgia. And it appears they're going to be involved in trying to figure out how this is going to work and work in a way to determine who wants to do it. They'll have to find another district attorney to at least look at the case. And they'll take it to them. That the district attorney will pick it up. And from what's being stated by many attorneys in Georgia who practice on law Twitter, and also J-Rock, it's done. Most of these prosecutors, when this has happened before, other types of very political cases, the district attorney who comes in and takes over says, yeah, we're not doing this. Dismissed. So this one's going away. This one is going away. And it is ridiculous when you think about it for Fani Willis. She had the ball on the 1-yard line and she fumbled it. I mean, she had this. Now, part of her issue was she dicked around for years and years. But she had it as like you just had to pay your boyfriend. You just had to hire him, didn't you, Fani? Fani. You just had to do it. Then you just had to go up there and run your fucking mouth in the hearing. Like, you know, it was hers to lose. Now, ultimately, would this case have probably fallen apart? Yeah, we've seen the caliber of the Fulton County Prosecutor's Office through the YSL trial. They're a bunch of fucking tools. But she, you know, it was hers to lose. And it's hilarious to watch someone like her, you know, sabotage it all just because of some dick. Yes. Hashtag woman moment. Does Jenna Ellis still have to serve whatever this punishment she pled out to? Yeah. Yep. This doesn't affect other cases where they've been resolved. They don't get to come back and say, oh, wait. We want to jump back in and get that verdict. No. You pled out, and then the other guy ended up going to the distance and got a better deal. That happens. But in the same vein, let's say you pled out and then your co-defendant goes to trial and they get smoked. And they get convicted of everything and you only pled out to one thing. He doesn't get to turn around and say, like, wait. I want what they got. No, it's gone. It's all gone. You can't get it. So, no. Jenna Ellis, Sidney Powell, Chesbro, all the other people who were involved in those pleas, those other attorneys that took a plea out there, they're done. It's not coming back for them. And Snoop says, Fani has a long history of corruption. Yes, she does. Fani Willis is, she's just bad news bears. And the funny thing is, apparently she was well respected and well liked before she became the district attorney and before she started screwing around in public office. Like, a lot of people liked her. But then she became the DA, and it was just, like it took hold of her, corrupted her. So, yeah.